Welcome to this remote session of the Florida Supreme Court. The case that we consider now is in re amendments to Florida Rule of Criminal Procedure 3.851 and Florida Rule of Appellate Procedure 9.142. I'd like to first recognize Judge Sisko.
Thank you very much, Chief Justice Kennedy. Can you hear me?
Indeed.
Okay, thank you. May it please the court, I am Judge Michelle Sisko, and I'm appearing on behalf of the Criminal Procedure Rules Committee of the Florida Bar. I'd like to thank you for allowing me to appear remotely. If I could, I would like to begin with my committee's comment regarding the deletion of the automatic appeal requirement currently contained in Rules 3.851 and 9.142, and that would be automatic appeals of the trial court's granting of either a motion to dismiss a post-conviction motion or a motion to discharge counsel in a post-conviction proceedings. Our committee unanimously voted to retain this important guardrail. Death is different is a common refrain in the trial courts when dealing with these cases, and our committee feels that maintaining this important safeguard is in keeping with this sentiment. And again, this was a unanimous opinion amongst all of the members of this committee. Moving next to the removal of the requirement in Rule 3.851, the capital defendants must be represented in all post-conviction proceedings. In discussing this issue as a committee, we reviewed the court's 2013 opinion in Lambrix versus State, Lambrix, as well as this court's opinion in 2014, which actually implemented the change to require representation of counsel for capital defendants in a post-conviction proceeding. As you all are aware, Lambrix was a capital case authored by this court in 2013 before the rule change occurred. In that case, the trial court summarily denied the defendant's fourth and fifth successive post-conviction motions and denied the defendant's motion to discharge his appointed counsel. In that opinion, this court acknowledged a capital defendant's right to self-representation, but stated at page 900 of that opinion, quote, any right of self-determination and self-representation during post-conviction proceedings, however, does not outweigh this court's solemn duty to ensure that the death penalty is imposed in a fair, consistent, and reliable manner, and to guarantee this court's administrative responsibility to minimize delays in the post-conviction process. In denying the defendant's writ of prohibition for the trial court's denial of defendant's motion to discharge counsel, this court cited to the United States Supreme Court opinion in Martinez versus California. In Martinez versus California, the United States Supreme Court held that in the federal system, there is no Sixth Amendment right for defendants to be permitted to represent themselves in the appellate process, as the Sixth Amendment guarantees only apply to individuals who had not yet been convicted, and that the status of defendants in a post-conviction posture were constitutionally distinct from those pending trial. The United States Supreme Court did, however, create an exception for state court post-conviction procedures as dictated by the respective state court constitutions. Secondly, in that opinion in Lambrix, this court additionally noted that the defendant had already requested counsel to be appointed when the death warrant was issued. The court noted that permitting the defendant to discharge counsel at that stage, at the current stage in the post-conviction proceedings, but then reappointing counsel when the death warrant was issued would, quote, only create delays when the death warrant was issued, close quote. After considering all of these aforementioned cases, our committee, by a vote of 30-5, voted that the requirement for the appointment of counsel for capital defendants in post-conviction proceedings should remain. The majority of our committee expressed the same concerns as expressed by almost all of the other stakeholders that submitted comments in this case. For example, inevitable delays of this court's stated goal of resolution of all post-conviction proceedings for capital defendants within 2 years of the filing of the initial post-conviction motion. The logistical issues of an inmate on death row conducting discovery, and particularly discovery depositions. The lack of the defendant's ability to obtain records, not only from the repository, but any other outside sources. Particularly, there's been a number of technological advancements since Lambrooks was decided in 2013, and that is a lot of discovery exchanges now occur in an electronic format. That would be particularly difficult for inmates on death row. Even the most basic issue of the ability of capital defendants to file motions electronically through the portal would represent challenges. We discussed as a committee that these issues are particularly acute in death warrant proceedings due to the compressed timeline, particularly if an evidentiary hearing is required. As you all are well aware, the governor will include an execution date on the face of the death warrant. This then sets in motion an extremely expedited process for the courts to resolve all post-conviction matters. By way of example, I've handled 2 of these death warrant proceedings before, the most recent one being in 2019, that of Bobby Joe Long. In that case, the governor signed the death warrant on April 29th of 2019. The execution was scheduled for May the 23rd of 2019. As the presiding trial court judge, I was given until May 6th of 2019 to conclude all pending matters at the trial court level and to issue a written order. In Mr. Long's case, this included an evidentiary hearing with expert witnesses regarding Mr. Long's individual medical condition and whether the 3-drug protocol for execution would implicate the 8th Amendment prohibition against cruel and unusual punishment. This was a total of 8 days for the trial court judge, meaning me, to complete an evidentiary hearing with expert witness testimony and author a written order. I was only able to meet this deadline with the accompanying professionalism and tireless work of counsel for the Attorney General's office, defense counsel, and counsel with the Department of Corrections. In all candor, I do not think that this would have been empirically possible with a pro se capital defendant. With all of that being said, I would like to acknowledge the minority position on our committee. I think this sentiment is one really of philosophy and is best represented by Justice Scalia's dissent in Martinez, where he stated, quote, "Our system of laws generally presumes that the criminal defendant, after being fully informed, knows his own best interest and does not need them dictated by the state. Any other approach is unworthy of a free people. As Justice Frankfurter put it for the court in Adams versus United States, to require the acceptance of counsel is to imprison a man in his privileges and call it the Constitution." Thank you very much, Justices. It's been an honor and a privilege appearing in front of you today.
But before you move,
I've got a question.
Yeah.
And I understand the concerns, and let me say before I get to my question, we appreciate your comments, your committee's comments, and all the other comments that the court's received. This is a thorny issue, and obviously there's some deep philosophical differences swirling around here, and we appreciate the various opinions and the various points that have been made. But let me ask you about one thing. We started on this journey, I think, with Davis, and that raised some issues about the scope of a defendant's waiver of claims. Do you have any thoughts about how we should address that? I mean, one view is that there's a if you're gonna waive proceedings, that's once and for all and forever. That's not the position the court took. We thought that that was not what we wanted. The majority did not want that. There's also the thought that, well, you could only, maybe you should only be able to waive the claims that are actually currently pending. Another thought is if you do it expressly, you could waive those claims and any other claims if you do that expressly, but that you would not, just because you waive the claims that are now pending, that would not be construed as a waiver of all future claims. Do you have any thoughts about how that should be structured?
Well, and thank you, Justice Kennedy. And again, my committee did not discuss this particular issue, so I'm giving you just my personal opinion. And so I just want to make clear that we didn't discuss it, and I don't want to be speaking on behalf of the committee. Based upon my own personal opinion, I do think that a defendant should be permitted to waive any and all claims. And I don't necessarily think that it has to be just pending claims. There would be two caveats to that, however, in my opinion. One would be for newly discovered evidence. If it truly constituted newly discovered evidence, I think that would be one exception. The second exception
so you're saying even if they said, I'm done with this process, I don't want any more of this, finished, and it's very clear that they intend to waive future claims of undiscovered evidence, of newly discovered evidence, you'd say they still shouldn't be able to do it. I just want to be clear about that.
Well, it causes me some heartburn because you don't know what you don't know. Right. And what if suddenly, as a capital defendant, you've waived all of your post-conviction rights, and then you get a letter from the FBI that says, oh my gosh, the DNA testimony that was provided to convict you was actually faulty, and it can't be relied upon any further. And I do think at that point, then it would be a grave injustice to prohibit a defendant from raising that issue. So that's why I would one exception would be newly discovered evidence for me personally. The second one would be in death warrant proceedings, because there's two issues. Stepping back with death warrants, they don't always require an evidentiary hearing. The first one I did not require an evidentiary hearing. I ruled, it was really matters of law, and I ruled on them. There were challenges to the 3-drug protocol for executions, but that issue had already been settled by the Florida Supreme Court, and there was not reason for an evidentiary hearing, in my opinion. In Mr. Long's case, he had a specific medical condition, and because of that medical condition, his argument was that the execution protocol would inflict cruel and unusual punishment on him. The second exception that I can think of for death warrant proceedings is if there is a change in the 3-drug protocol for executions. I think historically what you all have seen is that there will absolutely be a challenge. The first defendant post a change in the execution protocol, drug protocol, that there will be a constitutional challenge to that protocol for the first defendant under a death warrant, and an evidentiary hearing will be called for. So I do think, again, with defendants, their medical condition may change over the years they're incarcerated. The 3-drug protocol may have an impact on them that hasn't been contemplated. So those would be three exceptions, I would say. Well, two. One for death warrants. I do think that death warrants should be excluded, and I do think for newly discovered evidence. Other than that, I do think defendants have the absolute right, as all defendants do, capital defendants as regular defendants, to make the knowing, voluntary, and intelligent waiver of all post-conviction claims.
Right. Thank you. Justice Poston, I think you had some questions.
Just let me quickly ask, what's your and the committee's view on the utilization of standby counsel and when there's a death warrant going on?
Well, again, we didn't discuss that issue specifically because the vast majority voted to retain counsel, so that the defendant should still be required to have post-conviction counsel. So again, I cannot speak to that as far as what the committee feels. I could only speak to my individual opinion on that.
Well, you've got a lot of experience. What is your view on that?
Okay, so in full disclosure, I voted with the minority. So I was one of the 5 that felt that defendants should have the right to self-represent in post-conviction proceedings if they choose. That doesn't undercut all of the arguments I just made. I believe every word I just said regarding how incredibly challenging it would be. It would be incredibly challenging. But I do think that if I'm the last judge that defendant may ever see before they are executed, and that defendant truly wants to represent themselves, I would be inclined to let that defendant do so. And it really just comes down to a philosophical issue. With regards to the appointment of standby counsel, that would have to be automatic. But I do think some of the comments, I think particularly by the Criminal Court Steering Committee, they did make some really, really valid arguments regarding how standby counsel is not necessarily a great substitute. But my own personal opinion is that if the court were to change the rules, that would have to be automatic. It'd have to be, because for all of the reasons that I just discussed, all of the logistical issues, particularly with any evidentiary hearing.
So you started off with a pretty compelling account of your death warrant experience and the tight time frame, and you concluded your story there by saying that you wouldn't have been able to do it without counsel. And obviously you were just sort of the first step in a process that was going to have steps other. So if there had been delays, I mean, could you just sort of play out for us? I mean, are you suggesting that unless the governor then sort of readjusts his time frame to account for the self-representation, I mean, are we essentially kind of introducing inevitable delays into these things, or what?
In my opinion, again, I'm not speaking on behalf of the committee, but in my opinion, yes. I think then the governor would have to be cognizant of the fact that a self-represented defendant who is on death row is going to face challenges in litigating their post-conviction proceedings that a represented defendant would not. I stand by what I said. If Bobby Joe Long were today, if that same case, and I was only given 8 days, I do not believe I could complete it in 8 days. I do not. Effectively and fairly.
Thank you.
All right. Well, we thank you very much, Judge. Now
Thank you.
Go to the next to Ms. Kiefer.
Good morning. May it please the court, Suzanne Keffer on behalf of Capital Collateral.
I'm sorry, I mispronounced your name. I apologize.
No problem. On behalf of Capital Collateral Regional Counsel South. So the comments that we submitted to the court focused primarily on the issue of self-representation. And we urged the court to contemplate whether or not a capital defendant should be allowed to represent him or herself based on several considerations: practical considerations, administrative considerations, equitable and constitutional considerations. Remarkably, and I say this having been in the capital post-conviction arena for some time, all of the agencies and committees that submitted comments agreed that a capital post-conviction defendant should not be permitted to represent himself. And they agreed across the board on those reasons that I just mentioned. Like I said, that's an agreement that we don't often see in capital litigation, for sure. I wanted to talk a little bit, and Judge Sisko did mention some of the practical considerations, but as an attorney representing capital post-conviction defendants, the practical considerations really are substantial. And I think at the heart of those considerations is access. Access to witnesses, access to records, legal materials, access to experts, access to opposing counsel, and most significantly, access to the court itself. There simply is too many moving parts in capital post-conviction for a convicted defendant to be able to navigate from death row. One of the most significant areas, and it is a large part of capital post-conviction litigation, is public records. The public records litigation that we partake in is unique to this area of the law. Rule 3.852 applies only to capital post-conviction. What that means is that this is beyond the discovery that a defendant would receive pre-trial. This is volumes and volumes and volumes of records.
Counsel,
and they come in the form.
These are obviously very significant real world considerations that the court is very mindful of, and that I think the commenters are, as you say, unanimous about. I wonder if you could respond, however, to what Judge Sisko was saying about the role of waiver in this entire consideration. What role, what importance do you ascribe to waiver, for the defendant who doesn't want the volumes of evidence, who doesn't want to make the kind of deep dive that you're suggesting is very difficult to make? How does that figure into your analysis?
So it depends on if you're talking about waiver of the post-conviction proceedings, or you're saying waiver of and dismissal of counsel to represent yourself. One, waiver of proceedings, we're all familiar with Davis, and I think that certainly I would echo their right to waive the proceedings as long as the procedures are in place to make sure that that was reliable, and that involves the automatic appeal to this court of what occurred in the trial court. I do agree with Judge Sisko, though, that there are issues that arise that the defendant may not know. As she said, the defendant doesn't know what he doesn't know. There can be changes in law of constitutional magnitude. We saw that with Hearst. There can be, as she said, newly discovered evidence. There have been times where we, without reaching out for the information, have received letters that may suggest Brady or newly discovered evidence. And certainly there are issues that arise during a death warrant, litigation of method of execution. While it remains that it's lethal injection, the drug protocol has changed many, many, many times.
I think I'm willing to stipulate that going without counsel in a death proceeding is a bad idea. Like, let's just assume that everyone agrees that it's a terrible idea, and there's nothing to recommend it. I guess the question is, what do you do with the sort of the core fact that it is still within the realm of someone's choice to, fire a lawyer, not want to proceed? How do we thread that needle? What is the rule you'd have us have?
Honestly, I think the way the rule is written now, where and taking into conjunction Davis, that other issues may arise that he would need counsel for. I think it's worked in that there are procedural safeguards in place so that when a defendant makes that choice, his competency is reviewed, and then a colloquy is conducted of the defendant, provided he's competent, he's been found competent. And then there is the safeguard that the defense attorney that has been fired files the automatic appeal. And that's the safeguard that needs to be in place to ensure that the trial court and the prosecutor and the defense attorney have gone through the process in place to determine that the defendant, like I said, is competent, and that this is knowing, intelligent, and voluntary. So I think that in terms of the automatic appeal, that is something that needs to remain in place. I want to go back a little bit because you mentioned what do we do with a defendant that doesn't want to avail himself of all that the post-conviction process allows, from filing 3851s, the public records process, whatever it may be, interviewing witnesses, hiring experts, whatever it may be. If the assumption is that they're going to represent themselves, but not avail themselves of what the post-conviction process provides, then we're talking about review that is not meaningful and effective. And I think that's where.
But counsel, how do you respond to the point that if they are fully informed and an explanation is made about the difficulties that will be attendant with self-representation, just like we have in the Feretta context. I mean, obviously, it's not easy to represent yourself in a capital murder trial either. I mean, there are all kinds of issues and difficulties with a defendant who does that, but they're told, and if they decide to do it, then the difficulties are difficulties that they have chosen to assume. How do you respond to that?
Because I think that the post-conviction process and the rule that they be represented by counsel speaks to how the death penalty is administered in the state of Florida and how it must be administered in the state of Florida to meet the demands of Furman. And all of these things have been put in place in order to meet what the United States Supreme Court required. And so when you do away with that and you say, well, they've made this knowing waiver, they're not going to have public records, they know they're not going to because it's difficult, you're taking away a piece of that component. And I started to say that the problem with that is it's not just a disruption of the criminal justice system, it's really a disruption of constitutional magnitude.
But counsel, I'm sorry to interrupt you. It seems to me though that your stronger argument is the disruption to the system, because it seems like there's and maybe I'm not sure if I'm understanding the question right, or even my understanding of this proposal is that if the court allows self-representation, that the system is going to essentially have to try to accommodate that by giving the person access to a law library, giving them records, giving them a way to meet with people, et cetera, et cetera. It hasn't been my understanding that we're going to proceed in a way that says to this person, yes, you can represent yourself, but if it's not convenient for us to allow you to do all these things, then you're out of luck. That's sort of a consequence of your decision. So to me, I understand in some way the philosophical thing about personal choice, but the person has put themselves in a position by having been convicted of a capital crime and have it be affirmed on appeal, et cetera, that they're essentially making a choice that's having all these collateral consequences for a lot of other people, including the victims' families who are going to be subjected potentially to these delays and yada, yada. And my understanding of this rule proposal is that that's sort of baked into a proposal to let someone represent themselves. I mean, is it your understanding that if someone chooses to represent themselves, that they aren't going to be, people aren't going to have to try to accommodate the records and the witnesses, et cetera, et cetera?
I think that the problem is, how do those accommodations happen? How do they happen in the face?
Right, but the point is the system is going to, but let me just ask you though, forgetting the logistics of how, isn't it your assumption that they will have to try to be made? I mean, putting aside like how it's, I mean, obviously we can't anticipate all the different things. Is the proposal, as you understand it, as all the commenters understand it, that essentially if the burden, the burden is on the self-represented, petitioner or litigant, whatever you want to call him, or are we going to have to try to essentially facilitate his self-representation by doing whatever it takes logistically to give him access to the things he would need to be able to do?
I would think certainly if this is the route that the court goes to allow somebody to represent themselves, then all of these different agencies and the court and the state attorneys, they are going to have to accommodate that defendant. But what our comments point out is that's beyond difficult in this circumstance. We, and I won't belabor it, but we laid out in our comments the case of Salazar. And the court allowed Mr. Salazar to represent himself. I don't believe they got much further than additional litigation over the litigation that already is inherent in public records. They had to appoint a special magistrate to go through the records and decide which ones comply with DOC's administrative code, what he could receive. I mean, there's just certain security concerns that I don't know that they could do away with them and allow a self-represented capital post-conviction defendant to be able to adequately represent himself. And so we spelled out some of those problems in our comments, and ultimately, Mr. Salazar was appointed counsel again, because it simply it was not working, and the state had to point out Gordon and what Gordon says and the fact that it wasn't working. So while they seem like, you know, impracticalities that maybe can be accommodated in reality for the stakeholders in this process, we know it's not going to happen. And then that's when it's not just delay, it's not just disruption of the streamlining of this process, it becomes concerns of constitutional magnitude. It affects the fairness, reliability, and consistency of this process.
Let me explore with you and try to articulate and get your reaction to my concern about the rule as it exists. And let me start with my assumption. The way it works is that a capital convicted defendant has only two options. They can waive everything and therefore not be heard in the state court of last resort in the case in which the sentence of death is imposed, or they can keep counsel, but not really have a say in what counsel does. They may want to say to us, this is my life at stake, and this is the claim I want to make. And you may say that, well, that's not a claim that I can make, and so, but we're going to make all these others. I don't want you to make those others. Well, then you can waive everything, including the claim that you want to make. And so there are constitutional implications of that. It's a person that has a right of self-representation, and we're telling him that we don't care about your constitutional rights because it's just too hard. And that's troubling to me. What am I missing in that explanation of how it works and the choice that defendant is making?
I agree. I think that it is a troubling choice for a defendant to make, to give up all of his claims and not have counsel, or stay with counsel and, as you said,
and lose complete control of his defense in a case in which the state has imposed this penalty. You can't talk to the court. I mean, it seems like almost.
Well, really, you're losing control of offense, right, counsel, not defense. This is offense.
Sure, and I understand that, but counsel has a role for a reason. And I think Lambrix really addresses your question in this regard, because Lambrix filed claims and petitions and just over and over and over again. And the court constantly found that the claims were meritless, frivolous, and dismissed them. And required.
Let me ask you this: what if we had a procedure that allowed for the appointment of counsel, required it because of all the more indirect constitutional concerns that would suggest that counsel is needed and necessary, but have like an Anders proceeding, sort of an Anders sort of rule that you could, the client would maintain control. If the client doesn't want to bring a claim, then you would need to abide by counsel's wishes. And if the client wanted to bring a meritless claim, you could file an Anders type brief that said, my client wants to present this claim. I don't think there's a basis for it in the law, and here's why, but this is the claim. What about that kind of procedure that would allow you to shepherd him through? If the client agrees, make the best arguments that you can, but if the client doesn't agree, present no argument, or present whatever argument it is in an Anders type brief that the client wants to present. It's the client's case. It's not your case.
I understand that thought process. What I will say again, and I point the court back to Lambrix and what the court said in Lambrix. And I think that the point is that oftentimes the court is overburdened with pro se defendants filing claims that, like I said, are meritless or frivolous. And even in that scenario, the court would still have to be addressing these claims. And so Lambrick speaks directly to this. And it's exactly the situation of—
I can guarantee you that it would be much easier and much more efficient to address those claims coming from you in an Anders type brief that says, this is the claim, this is the law relating to this area, and this is what my client wishes to present. That would be significantly easier to deal with in most cases than the kind of pro se things that I got when I was on the 5th District Court of Appeal for 11 years.
Counsel, I mean, Justice Lawson is kind of offering you an off-ramp. I mean, your position isn't that, let me just ask it, not rhetorically. I mean, would you prefer Justice Lawson's alternative to the proposal to allow people to represent themselves?
I mean, certainly, I think that if there's a provision that allows us, as part of our 3851 or initial briefs or habeas, that would allow us to recognize an issue that the defendant wants to raise, that's certainly something to explore. That's not what was presented here. And so I'm not sure that I have explored that thoroughly and what that would look like. And so that's
well,
the best I can say.
I think he's suggesting issues that they wouldn't want to raise, but also a process where the court could hear, to the extent that the petitioner, him or herself, didn't want claims raised that the lawyer is saying they want to raise, then the court could say, do you understand, blah, blah, blah. And if the court is satisfied that the petitioner is making a knowing decision not to pursue those claims, then the client wins, not the lawyer, and the claim goes away.
Well, I think what you're referring to maybe, and I've had this happen, where I pled penalty phase mitigation claims, and the client allowed investigation, allowed to develop that claim, put it in the 3851, and then ultimately, when we went to evidentiary hearing, the client wanted to waive that specific claim. That was done against, at my objection. So I think that something that you're suggesting is already in place. They do have that right to waive a claim, as long as it's knowing. And the knowing is really the key, because it means that counsel has to have the ability to investigate and provide the entire claim to their client. And so I think what you're saying, Justice Munoz, is really already something that happens. There are scenarios where it's not all or nothing. You waive your entire post-conviction proceedings because you don't agree with what counsel wants to put forth. There are scenarios that they waive a claim. They don't want a claim. They don't want you to put a lethal injection claim in there, whatever it may be. So that scenario has taken place, and they do have control in that sense of what is being pled.
All right.
If there are no other, I'm sorry, go ahead.
No,
if there are no other questions.
I was going to say thank you.
Yes, thank you.
Thank you. We'll move on to the criminal law section.
May it please the court, Maria Deliberato, and I'm arguing on behalf of the criminal law section of the Florida Bar. The criminal law section's comment opposing the proposed rule change was informed by its capital cases committee, which consists of judges, prosecutors, defense attorneys, law professors, in order to ensure a balanced approach in this very complex area of law. I won't belabor echoing all the comments this morning regarding the logistical and practical challenges, but this widespread agreement among all of these stakeholders does weigh in heavily in favor of this court declining to adopt the proposed rule changes. I want to speak further, and I will certainly address any questions that this court has, and we'll try to follow up on questions that have been asked. But I would like to speak that allowing self-representation, and that was the focus of the criminal law section's comment, though I can certainly touch on the other issues, allowing self-representation in the face of these logistical and practical changes actually rises to a level of violation of due process that's required in these capital cases and does really jeopardize and undermine confidence in the reliability of Florida's death penalty. And this court has recognized that, right? In Gordon v. State, this court recognized its longstanding and solemn duty to ensure that the death penalty is administered in a fair and consistent and reliable manner. And this, of course, comes from the United States Supreme Court itself, which says the Eighth Amendment only allows the death penalty if it can be imposed fairly and with reasonable consistency. Otherwise, it can't be imposed at all. And so, of course, Florida is required in its constitution to interpret, in this court, to interpret its laws in accordance with the United States Supreme Court.
But that right, with all due respect, the right that the U.S. Supreme Court is talking about is a right of the defendant, is it not?
Yes, a right of the defendant to have, well, I mean, yes, but it's also, if the citizens of the state of Florida and of the states that have the death penalty, there's also an inherent duty for victims, for all stakeholders, to be sure that we are administering the death penalty in a fair and reliable manner. It's not just for the defendants.
It just seems so.
I understand that that's has been understood in that way, but I don't know that I see that in what the U.S. Supreme Court has said. But
Yeah, I mean, it seems like your best, the unreliability and all that seems, then, I mean, that really is an individual thing. It seems to me the more compelling arguments that all the objectors are putting forward is, we're not living in some libertarian paradise where somebody can just make this choice and they live with the consequences and, that's their decision. I mean, they're going to affect the entire system, the victims, the state attorneys, the DOC people, the people who have to be standby counsel, et cetera, et cetera. So it's not one of these deals where someone's just exercising some right of autonomy that's only going to affect them. It's affecting a lot of other people too, in a way that's not, and my personal concern, just speaking for myself, isn't, some concern that somehow their right to a fair review is going to be violated. My concern is what they're doing to everybody else through, the selfishness of, and again, we're not talking about a defensive posture. This is post-conviction, so they're on offense. They've already been found guilty, et cetera, et cetera. They're imposing all kinds of costs on a lot of other people because of essentially for like not because of a constitutional right to self-representation, but because of some kind of commitment to like a policy idea or a philosophical ideal of autonomy.
Yeah, Your Honor, and I think actually that speaks to Indiana versus Edwards from the United States Supreme Court actually speaks to some of that. With respect to the right to self-representation at trial, even that is not unlimited. And it actually talks a lot about that, the dignity and the autonomy, and that's sort of the reason behind these self-representation cases. But there are limits, and there are limits even at trial when doing so would do exactly what you're saying, which is overburden the system, make a mockery of the system, allow for decreased reliability in the process across all aspects. So I think there is precedent for this court to keep the rule as it is, because there is no absolute right to self-representation in post-conviction. It's a completely different standard, as Your Honor has noted. And so there's definitely historical approach and support for limiting that right in a death penalty case. As we've all said, death is different. And so the concern, I think, is that it really could undermine reliability. The way that I was sort of thinking about it and presenting it to the court was, Florida has a unique system of capital post-conviction representation. It's actually very unique among other states. Most states do not require or have an organized system in place of capital post-conviction representation. Our legislature has created the CCRCs, and this court has ratified that system actually to the favor of dismantling it. There was a period of time where CCRC North was closed and it went to the registry as sort of a pilot program. And I mean, a fair look at that, chaos ensued. There was deadlines missed. There was a lot of lawyers who didn't know what they were doing capital work. And this court, and when the Time of Justice Act passed and they brought back CCRC North, was exactly for that, to bring back this reliability, this uniformity in capital post-conviction representation, so that there aren't delays, so that there are, fair and process that goes forward. And so to me, and speaking on behalf of the comment, that if we go back, if we allow this self-representation, it really will devolve the system into chaos, much like it did when CCRC North closed. And, Florida and this court has authorized this really organized system of capital post-conviction representation. And these rule changes set that back and really put the system at risk of undermining the reliability in the system, which is required if we're going to have a death penalty. I'm happy to talk and sort of answer about the, to Justice Lawson's comment about the claims and waiver of the claims and the conversation with Ms. Keffer. I do think that the rule as written is really already allows for that. So 3.851 requires the lawyer to certify that they've gone over the claims with the defendant, that they've explained all of the claims that are being made.
The cases that I've handled since I've been here where a defendant wanted to represent themselves, what they wanted to do is present a claim that their attorney said wouldn't be a viable claim. And so they want their one chance to present the case that they want in their case, a legal argument. And we say, no, you can't be heard on that. You can have a lawyer, but you can't be heard on that.
And so I think that, again, and like Ms. Keffer, I've been doing this for a long time, and those situations have come up where sometimes we do present a claim to the court exactly how Your Honor described in an Anders style, which says the client very much wants this claim to be raised. This is the law. This is why we don't think it's appropriate. And candidly, some of those claims are a direct result and product of the client's severe mental illness. And that's really what nobody has mentioned as of yet. I know the commenters mentioned it and the Mental Health Coalition has commented. The vast majority of the defendants who want to represent themselves have severe mental illness and perseverate into delusional claims. I had a client.
That's a competency issue.
Yes and no. Indiana versus Edwards talks about exactly that, right? So you can be competent to stand trial and also be so severely mentally ill that you cannot, in fact, present your case to the court in a competent manner. I've had clients who had fixed delusional beliefs that all of the experts agreed and that the court and the lower courts have found with respect to cases. I had a client who routinely believed that he was held without counsel and that Gideon versus Wainwright entitled him to automatic release, not just relief, but release. He had 50 years and 5 life sentences in another state. He perseverated on that claim for years. He filed repeated pleadings, and ultimately the court found him not competent to proceed, period. But for a period of time, he was found competent to proceed, but not competent to represent himself for that exact reason. So I think that the sort of hybrid that Your Honor has talked about is actually already in place without making these proposed rule changes. The last thing that I'll say, and then obviously answer any questions with respect to the waiver, I do echo the sentiment of everyone that keeping the direct review of a waiver is critical for this court. This court, again, its solemn duty is to safeguard and make sure that our death penalty is reliable and administered fairly. And allowing this direct review procedure when there is a complete waiver really does support that goal. And the resources, I understand obviously anytime a case is before this court, it expends resources with Your Honors and law clerks and the lawyers filing briefs, but they are sort of a rarer appeal process. And I just think that doing away with that really does strip a really important safeguard that I think the federal courts, as they are going to review these cases, as they do review all the death penalty cases in one way or another as it happens, is really that gives them a benefit of a state court finding, of the highest state court making a finding that appeal was knowing and that waiver was knowing and voluntary. I'm happy to answer any further questions. We would, of course, in order to ensure fairness and reliability in Florida's death penalty scheme, we urge this court to decline to adopt the proposed rule changes and to continue to prohibit self-representation and post-conviction and maintain the direct review. Thank you very much.
Right. Thank you very much. Ms. Rowe.
Good afternoon, Your Honors. May it please the court. My name is Laura Rowe and I represent the Appellate Court Rules Committee. It's so nice to see you all again this week. I think it's a rare pleasure that I get to see you all twice in 1 week, but I'm glad to be here and thank you again for letting me appear remotely. Currently, Rule 3851 prohibits a defendant who has been sentenced to death from representing himself or herself in capital post-conviction proceedings. And it also requires that a motion seeking dismissal of post-conviction proceedings include a request to discharge counsel. The court's proposed amendments to Rule 3851B6 eliminate the prohibition against self-representation and the requirement that any waiver encompass both the dismissal of pending post-conviction proceedings and the discharge of counsel. In preparing its comment, the committee considered whether automatic review of such orders is still necessary and appropriate, with a majority of the committee agreeing that it still was. The committee also identified a few concerns with the current amendment language as it's been drafted, specifically regarding the role of discharged and standby counsel in the proceedings. And finally, the committee discussed at length the issue of self-representation for capital defendants, with a majority agreeing that the assistance of counsel benefited defendants, the court, and Florida's capital justice system, but ultimately concluding that whether such a right exists is a legal question for this court to determine. In proposing the amendments that are under discussion today, this court specifically asked whether maintaining the rule provisions providing for automatic appeals when a motion to discharge counsel or to dismiss the capital post-conviction proceedings or both is granted continue to be necessary and appropriate. Ultimately, a majority of the committee, the vote was 29-10, concluded that the rules should continue to provide for automatic review of orders, discharging counsel or dismissing post-conviction proceedings. However, the committee identified a number of factors for the court's consideration on this issue. In support of the minority position that automatic review is no longer necessary or appropriate, the committee identified two practical factors. One, automatic appeals from orders dismissing post-conviction proceedings and discharging counsel add to the time it takes to resolve a capital case. They take about a year or more to litigate, even with an expedited briefing schedule. And the committee, as a practical matter, did not locate any reported case that in which this court determined that the defendant was actually incompetent to effect a waiver or that the waiver was involuntary. From a more fundamental, or as some other of the practitioners today have said, psychological or spiritual perspective, requiring discharged counsel to continue representing the defendant following an order granting a defendant's request to discharge counsel and finding that the defendant was competent to make that decision would seem antithetical to the defendant's right of self-determination. The minority of the committee members felt that a defendant who succeeds in moving to discharge counsel should be permitted to proceed pro se and to decide whether to proceed with the case at all. Based on some of the comments from the court this morning, I did want to point out for the court's benefit that in such a situation under Rule 3851I, I think it's sub 8B, if the motion is granted and counsel is discharged, discharge counsel is currently directed to both file the notice of appeal, the notice seeking review in the Florida Supreme Court and to file the initial brief. However, both the defendant and the state are permitted to serve responsive briefs. So the defendant's participation as a pro se litigant is not totally barred by the current language of the rule amendments. The committee also discussed several factors in support of the majority position that automatic review is still appropriate at this time. Primarily, the committee was persuaded that automatic review currently functions as an important safeguard in Florida's capital justice system. If the decision to appeal is left solely to the defendant who sought the discharge of counsel or the dismissal of proceedings altogether, it's likely that such orders will evade appellate review. A defendant who has obtained the relief he sought is unlikely to voluntarily seek review of the very order granting him that relief. Appellate review of orders determining that a waiver of post-conviction proceedings or of counsel was knowing, intelligent, and voluntary, by its very nature, maintains confidence in the reliability of Florida's capital justice system, which, as other participants in today's argument have fleshed out in more detail, could have federal habeas consequences and other concerns down the line in a capital case. But compared to these concerns, the committee ultimately concluded that the resources expended in maintaining the automatic appeals in capital cases were comparatively minimal to the potential consequences of eliminating them. Regarding the proposed language of the current amendments, the committee unanimously approved the amendments to Rule 9.142D1 and 2 as being procedurally consistent with the proposed changes to Rule 3851 and the changes permitting a capital defendant to either discharge counsel or dismiss a post-conviction proceeding consistent with this court's ruling in Davis v. State. However, the committee had a few concerns regarding the proposed language as currently drafted. First, as regarding discharged counsel, the proposed amendments to Rule 3851I and 9.142D both contemplate that discharged counsel will file a notice seeking review and the initial brief. However, if the order to be reviewed does not in fact discharge counsel and only dismisses proceedings, there would be no discharged counsel in order to direct filing the notice of review. That flows into the committee's concerns regarding the language about standby counsel. The proposed amendments to 3851I9A require the court to appoint standby collateral counsel, regardless of whether the post-conviction court actually discharges collateral counsel. Now that we're allowing defendants to choose either to discharge counsel or dismiss proceedings or both, there could be a situation in which defendants choose to dismiss proceedings but not discharge counsel. We believe that this issue could likely be corrected by amending the new proposed language to apply only when a motion to discharge counsel has actually been granted by the post-conviction court. The other issue identified by the committee regarding standby counsel is that once they've been appointed, the role of standby counsel is not defined in either rule set. While discharged counsel is referred to and given some instructions, standby counsel is not. If it's discharged counsel that should file the notice of appeal and the initial brief, and standby and discharge counsel happen to not be the same attorney, it's unclear how standby counsel is going to participate in the following appeal, if at all. The final thing that the committee discussed at length was self-representation. And as my time is drawing to a close, I will just note that a majority of the committee did vote and agree that the support of counsel in capital cases would likely be of benefit to defendants, the court, and the timely resolution of capital cases based on the factors identified by other commenters. We noted especially the comments of the Florida Mental Health Advocacy Coalition and the comment of the Department of Corrections regarding the serious limitations on self-representation for especially capital defendants in the current system as it exists today. If there are no questions from the court, I will conclude, but I'm happy to answer any questions if you have them. Thank you.
Thank you, counsel. We thank all of the participants in today's argument for their arguments and all the other commenters for their participation in this case. That is